compliances and the scrutiny is concerned, in the current scenario, most of the adjudication orders that we are seeing, very few of those orders are initiated by ROC. Majority of the orders that we see today are the suo motu applications that companies are filing, maybe as a result of some audits being undertaken, due diligence in terms of some investment activity going on in the company. And therefore, companies are going themselves to the ROC saying that we have defaulted in this provision and then impose a penalty. This filing of suo motu application for adjudication has not been recognized under Companies Act at all. There is no procedure prescribed. So when we say suo motu application, what they do is, from the ROC's point of view, it is just a plain paper application saying that we have defaulted, punish us. Is the simple outcome of that. And adjudication penalties are imposed. Now from that point of view, when we look at what is in the proposal, is that, like all of us must be aware that earlier incorporations or approval of various forms used to happen at the respective jurisdictional ROC offices. Now everything is centralized. So there is a central processing center which processes, addresses all the forms, right? There is also a proposal now that central scrutiny center being set up. Now when all the V3 forms that we have been seeing over the last 1.5 years, you must have observed that there are a lot of details that are embedded in the form itself. So compliances and the monitoring of compliances is being done through systems. The Central Scrutiny Center will again use certain additional technology tools to find out the defaults. When system will do something where human beings are not applying their mind, and I'm not sure if I should say it or not, but when you deal with ROC like offices also, they tend to generally go with the most conservative or harshest view possible. Now the three possibilities that we just spoke about, we will really not know what view they will come up with when they will have a central scrutiny center set up. So from that point of view, my suggestion here would be that बाकी कोई फॉर्म में कितना टाइम लगता है लगने दो, but at least annual accounts and annual return must be filed within 30 and 60 days. Now there will be a logical question that when MCA issues an extension of 2-3 months for filing, what happens? MCA does not extend technical point. So while we know that because MCA has only issued a circular saying that we are waiving off the additional fee for till December 31st, it means that MCA will, and as far as you are completing your filings before 31st of December, MCA will not necessarily go behind you for non-compliances, treating this as a non-compliance. But if you have to argue it purely on the legal point, then does MCA have an ability to grant extension? Answer is no. What MCA does is only waives off the additional fee that is applicable on delayed filings. So even if you are filing it in December, have we defaulted under Companies Act 2013 under 137 and 92? Answer would still be yes. While there is an understanding that they will not go behind us. So that will be done. But how the situation will change? Yeah. Correct. 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 So that is a subsequent action. So see, all these are, means Supreme Court has also in many cases recognized this fact. So technical default, if it is there, if default is impossible, technical or venal defaults are not defaults. Supreme Court has said this in multiple cases. But all of this will come to your rescue at the subsequent stages. ROs will not accept this. The way they will look at it. So if anybody would have attended the adjudication hearings, would have seen that no matter what we are mentioning during the hearings, the orders that they will pass after the hearings will not carry anything of this. So that is a unfortunate situation that is there. And sorry. Yeah. Yeah. So some things are getting dangerous here. Yeah, that is that. So that is going to be the point, and that's where my point was that because of the approach that we have seen they have, we really never know what weird view they will come up with in terms of these issues. So as far as possible, being on the conservative side would be helpful, and I agree that taking a conservative view, I always believe in the fact that taking a conservative view, one need not be an expert. Taking a right view, you need to be an expert. But sometimes dealing with such situations and what you are talking about, I think it makes sense to be conservative on such matters where you don't have threat of only losing, defaulting under one provision, but attracting so many other defaults under the act. So here, I think it makes sense to be conservative. So that is one point that I wanted to just bring out on the table here. Ah. Yeah. So if you read it carefully, no, ultimately the conclusion will be your additional fees waived because ROC, MC for that matter, does not have a power to grant extension from on the filing dates. So sorry? No, no one. So there is no power given under Companies Act, unfortunately. So ideally what should have happened, therefore, is what they have done to go to a very extreme level by removing reference of 403 section from 137 and 92, that should not have been done. So as far as we are paying additional fee and we are complying it, that day the default ends and we can say that default is made good. But unfortunately that has not been done. I'm not sure if that has been identified by them or not also. Because had that been the case, they would not have amended section 454 subsequently in 2020. So that was one point. So just be careful about 137 and 92 was the underlying point that I wanted to bring out on the table here. After this, now coming back on the scheme. So as I said, scheme begins on 15th of April, ends on 15th of July. There is a 3-month window available. The logic why MCA has announced it so much in advance while the commencement date is a few months down the line, the logic appears to me is that companies during this period can ensure that AGM related activities, documentation activities, of course not possible because we are looking at previous period, but completion of documentation, completion of financial statements, everything companies can start working on it so that on 15th of April when the scheme begins, we are in a position to ensure that we are taking the best benefit of this window and ensure the compliance there. So earlier, whenever amnesty schemes were brought in by MCA, those schemes were applicable outright for every non-compliance, for every pending compliance. Unlike earlier schemes, this is a very specific key scheme. This talks only and only about annual filing related compliances and nothing more. So then this scheme also allows companies to apply for a dormant status if company is not carrying out any business, and dormant status can be applied by paying a 50% discounted fee. Has anybody present here ever applied for dormant status for any company? No, I'm sure nobody will, because while that provision has been there since beginning of the Companies Act 2013, it doesn't give you a very practical way for implementation. So this is a limited period dormancy. You can, if you are holding an IP, you don't have any current business plans, but you anticipate some plans in future, recent future, then for 5 years you can put the company in hibernation by treating this as dormant. But then what it tells you is that filings are required, audit is required, 2 board meetings are also required. So if we are agreeing in principally that company is a dormant, there is no business, what board meetings will do? So for a small company also now, we have only 2 meetings required, right? But if and those are active companies, this is inactive company, but still those compliances are needed. And there is no extension possible. So if you don't start any business within 5 years, means you don't resume the company back to normal company from dormancy, there is no way possible. So if you don't do that, extension is not possible. So because extension is not possible, the next course, if you don't do anything, then ROC will initiate strike-off process on that. So if that is going to be the outcome ultimately, That's why nobody has ever, in my knowledge at least, in my circle, I have never seen anybody making a company, getting a dormant status for any company. So that is, so be that as it may, but that is available. So if any company wants to do it, it can be done in a 50% discounted rate. Strike-offs. Major problem why ROC is concerned with these compliances and these schemes are brought in, strike-off mass actions we have seen happening. Why all this has happened is it impacts their MIS. So now active companies are 20 lakh in India, and out of that, what percentage are the complied or active companies is something that they look at from their MIS point of view. Now, unless they push for strike-off of the companies, they will not be able to set their statistics right, and that is why the mass action that we have seen between 2016 to 18 on striking off of companies and such schemes that comes in front. Now, if this opportunity will also be available for companies who are not carrying out any business, who do not intend to carry out any business in future, to just go for a strike off and the at a discounted fee again, companies will have to pay only 25% price and go for discount. So ideally, whenever it is always better that, so we were discussing some case that ROC has struck off a company but business is ongoing. That is possible only when ROC initiates an action. When we are voluntarily going for strike off, can we have operating business? No, because one of the preconditions for strike off applications is you should have closed your bank accounts. Your balance sheet should be nil. Your bank account should be closed. Resolution should be passed to take note of all these things being concluded, and then the strike off application goes. But therefore, it is always better that companies voluntarily takes up that action and files an application for striking off of the name of the company from the register, then waiting for any action being initiated from the MCS side. So that is another benefit. So pretty much this is just the very simple structure of the scheme. The relevance is again limited to annual filing forms under the current act or the previous acts. And the additional aspect that I brought in about the importance of compliance of 137 and 92. So are there any other questions now? Yeah. No, so there is a condition. So there are certain parameters that are given in section 248. One of them is for the newly incorporated company not commencing its business within 180 days. That is the first criteria. Second is company not being filing for annual filings for 2 consecutive years and not carrying any operations for 2 years. 2 years is the criteria. So if there is a company which has not been doing anything, but has not been doing anything only for 1 year, you'll have to necessarily wait for another year to put it for strike off. No. The only, sorry sir, only quick option probably, not for the recording, but